The New York Times, 5/27/97, editorialized, I'm sure with mixed feelings since jury nullification helps the left, strongly in favor of judges removing jurors who might be construed to be judging the wisdom of the law as well as the interpretation of the facts. But the New York Times knows the power of the people could weaken the powers of the federal government developed over the past 50 years through this process and literally repeal the interventionist state without waiting for a slow, plodding, and inefficient Congress to do it for them. This puts fear into the hearts of all big government advocates. Can one imagine what might happen if all non-violent crimes were ignored by jurors? We would suddenly have room in our prisons once again for the rapists, muggers, and murderers. District attorneys practice a form of jury nullification all the time and deciding frequently not to prosecute certain cases. Grand juries likewise fail to indict for personal or legal reasons in spite of the facts presented. Many state constitutions still protect the right of the citizens to practice jury nullification. Jury nullification is not perfect, but permitting it would be an improvement to the current system. Yes, there would be a chance that somebody might be freed for the wrong reason. But ultimately, in a free society, sovereignty must remain with the people and not with the dictatorship of the majority or an elitist, powerful government. There are enough mistakes made today with our jury system, and there is enough danger with a government that is growing out of control, that jury nullification, something available since 1215 AD, should be available to the citizens of this country. It could go a long way toward establishing a free society once again in America. According to Lysander Spooner, a mid-19th century writer, there are 5 separate tribunals protecting us from abusive government: the House of Representatives, the Senate, the Executive, the courts, and the common law jury. He maintains that all are important, but that the ultimate protection of our liberty must be placed in the hands of our peers. His essay on the trial by jury, 1852, deserves close study by all 20th century students concerned about the future of freedom in America. John Jay, the first Chief Justice of the Supreme Court, agreed with this principle. In his first jury trial in 1794, Georgia versus Brailsford, he stated, "You have nevertheless a right to take upon yourself the judge of both and to determine the law as well as the facts controversy." Jefferson was in agreement, quoting, "To consider judges as the ultimate arbiter of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy," close quote. The 20th century, however, has witnessed a serious erosion of this principle. Since 1895, Sparf versus United States, the right of the jury to rule on the justice and the constitutionality of the law, as well as the facts in the case, has been seriously undermined. Also, the lack of concern and understanding for individual rights has affected jurors, just as it has affected the representatives, senators, judges, and presidents. Jurors in recent times have been just as guilty of ignoring the principle of equal rights as have our representatives in our legislatures, judiciary, and executive bodies of government. These two factors have greatly diminished the value of the jury in the 20th century. Those frustrated with changes in the Congress, the executive, and the judiciary, and there is certainly good reason for frustration, must consider educating potential jurors as to the importance of the common law jury and the principles of individual liberty. An awakened citizenry participating in juries around the country could bring about a nonviolent revolution of magnificent proportion, reversing the sad trends of the 20th century. The jury today is a weak institution, as are all the other institutions designed to guarantee individual liberty. Proper effort could revitalize the jury and restore it to its rightful place in curtailing the endless growth of an all-powerful government. Several legal events in the 20th century had to occur for big government to thrive. The de-emphasis of the jury was crucial in the expansive powers of the omnipotent state. Judging the moral intent and the constitutionality of the law is no longer even a consideration of the jury. Today, judges instruct the jury to consider only the facts of the case, and then the judges become the sole arbiter of evidence admissible in court. Because of this, the jury system has become progressively weak over the past 100 years. In addition, judges write into their rulings grand designs for society. Our judiciary bodies have become legislative bodies. Another problem is that a major part of the judicial system has been removed from the people by placing it in the administrative branch of government. The agencies of government has usurped power unimagined by the authors of the Constitution. Administrative justice is a gray bureaucracy, independent of the legal judiciary. Regulations are written yearly by the thousands of pages, read by few and understood by no one. This is done intentionally to intimidate and harass the people. It is used as a political tool for selective prosecution. Regulations can favor certain industries while destroying others and providing great accumulation of wealth for the beneficiaries. Exemption from prosecution of some companies while others are pursued has destroyed many good industries and companies. Prosecution in the administrative courts requires great sums of money for self-defense. Juries are not available, and one is considered guilty until proven otherwise. Tragically, economic conditions usually prompt the businessman to pay the fine regardless of its unfairness to save legal costs. Fighting the system through political reform is not even a serious consideration. Those who could consider such a struggle are ridiculed as idealistic and unrealistic. A powerful political action committee and a shrewd lobbyist are today considered the best investments. Since we live with massive bureaucracy for over 50 years, most citizens uneducated in the ways of equal justice, equal rights, and freedom are unaware of any other system. By writing regulations with the force of law and administrative justice interpretations and enforcement of these laws, the administrative judiciary rulers have made a mockery of Article 1, Section 1 of the Constitution. Whether it's in the regular courts or the administrative courts, judges who grew up under the welfare ethic rarely concern themselves with the right to own and control the fruits of one's own labor. The right of society, as they see it, preclude what they claim is a narrow self-interest, the individual. Spooner argued eloquently for the right of the jury to pass final judgment on all laws. The moral intent of the law, the constitutionality of the law, the facts of the case, and the moral intent of the accused. Spooner's argument for allowing such responsibility to rest with the accused peers is that delegating responsibility only to the representatives in Washington was fraught with danger. He was convinced that all government officials were untrustworthy and susceptible to bribery, and that removal of our representatives in the next election was not sufficient to protect the people from unwise and meddling legislation. If we had heeded the admonitions of Lysander Spooner, we would not be faced with this crisis. Spooner began his essay on trial by jury by clearly stating the importance of the jury's responsibility to judge the law as well as the facts in the case. Quoting, for more than 600 years, that is, since the Magna Carta in 1215, there has been no clearer principle of English or American constitutional law than that in criminal cases. It is not only the right and duty of juries to judge what are the facts, what is the law, and what was the moral intent of the accused, but it is also their right and their primary and paramount duty to judge the justice of the law and to hold all laws invalid that are, in their opinion, unjust or oppressive, and all persons guiltless in violating or resisting the execution of such laws. Close quote. If a law is assumed to be correct constitutionally and morally merely because it's a law written by our chosen representatives, Spooner argued the government can give itself dictatorial powers. And that's exactly what has happened with the massive powers delegated to the president under the Emergency Powers Act. Power sitting there to be grabbed and used at the hint of a crisis. Spooner saw the jury as the last guard against such usurpation of the people's rights. Sadly, that protection is just about gone. The citizens of this country ought to restore the principle of trial by jury to its rightful place of importance. It could go a long way in reducing the burden of government now consuming more than half the energy of each working American. The time has come to stop the systematic attack on individual liberty pervasive throughout the 20th century. The Constitution must prevail. If we in the Congress fail to abide by the original intent of the Constitution, the last hope will remain with the people and the juries.
The gentleman yields the balance of his time.
I yield. Should he recognize me?
The gentleman from Texas.
Mr. Speaker, pursuant to House Concurrent Resolution 136, 105th Congress, I move that the House do now adjourn.
The question is on the motion to adjourn. Those in favor will say aye. Those opposed will say no.